Good day, ladies and gentlemen, and welcome to today's webcast. At this time, all lines have been placed on a listen-only mode. You may ask a question throughout the webcast by using the Ask a Question button located under the slide. Simply type your question into the box and hit Submit. If you should require assistance throughout the conference, please press *0 on your telephone keypad to reach a live operator. At this time, it is my pleasure to turn the floor over to Jim Christie. Sir, the floor is yours.
Thank you, Dagma, and hello, everyone, and welcome to our webinar today on Standing Apart from the Crowd, what directors need to know about executive compensation and when to vary from investor pay guidelines. I am Jim Christie, editor of Directors and Boards, and I will be assisted today by my two colleagues, Scott Chase and David Shaw. You will hear Dave Shaw teeing up your questions as we get into the presentation. A few quick housekeeping details. The webinar will run for 1 hour, ending at 4 p.m. Eastern Standard Time. Questions may be submitted at any time, and we encourage you to ask questions. We will get to as many as we can during this hour, and if some questions are still left unanswered, they will be addressed in a follow-up form. A replay of the webinar will be posted to the Directors and Boards website, and the presentation materials will be emailed to all registrants after the webinar. There is a materials button on the screen that you can play with and download the material as we go along. I think the functionality is very good on that, so you may try that if you want immediate access to the materials. Now, for CLE purposes, we will be announcing a verification code during this program. Attendees wishing to receive CLE credit need to record the verification code on their individual lawyer affirmation form. So keep your ear out for that as we get into the presentation. This webinar is for public and private company board members and executives who want a better understanding of how to enhance their board's processes and practices in executive compensation. We here at Directors and Boards have worked with Sherman and Sterling for many years in publishing their thought leadership advisories for boards and management, and have also joined together in presenting previous webinars. So it is my great pleasure to present these experts to this audience today. A brief bio note on our discussion leaders. Kenneth LaVerriere and Linda Rappaport are partners in Sherman and Sterling's Executive Compensation and Employee Benefits Group. Detailed biographies are on the webinar registration website and, of course, on the law firm's website. So all I will add here is that in their practices, they regularly advise board compensation committees and management on all aspects of executive compensation and benefits and related corporate governance matters. Joining in to add the dimension of a director's perspective is Darrell L. Lewis. Mr. Lewis is chair of the Compensation Committee of Universal Insurance Holdings Incorporated, which is traded on the New York Stock Exchange under the symbol UVE. He is an established trial attorney and has been a member of this board since June 2013. Again, a more detailed bio of Mr. Lewis is on the webinar website. We have a lot to cover, so at this time, let me turn the discussion over to Kenneth LaVerriere. Ken?
Thank you, Jim, and let me start by thanking Directors and Boards for organizing today's presentation. Helping boards and particularly compensation committees get it right, get the right results for shareholders and management is something that Linda and I are very passionate about, and we're delighted to be able to, share our thoughts today. I realize that I'm looking at Linda when I say this in preparing for today that she and I have almost more than half a century of experience practicing in this area. For our audience, I hope that means we're more than something than just old. We do have a lot to say, and we're delighted to share our thoughts with you. Let me also thank my personal friend, Darrell Lewis, chairman of Universal's Compensation Committee, and to my colleague, Amy Gitlitz-Bennett, who was key in putting together our presentation, and also is part of Sherman and Sterling's core team in our comp and governance surveys. So what are we talking about today? In broad strokes, we want to cover, looking at slide 4, two things. First, we want to help directors chart the best process forward when they conclude that, or when you conclude that varying from either investor guidelines or adopting what is sometimes referred to as a problematic pay practice is in the best interest of the company and its shareholders. What do you do? How do you approach that? What steps do you take to document it? How do you convince your shareholders that it's the right thing to do? We also want to discuss with you what happens if you get a negative pay recommendation from one of the proxy advisors after you filed your proxy, or worse yet, after the vote comes in, you find that you've got a negative or a low say-on-pay vote. We think there is an emerging best practice there. We'd like to suggest to you some steps that you can take. So looking at slide 4, two takeaways, one that's on the slide, one that's not. What will be obvious to everybody in the say-on-pay environment is that most companies, get a favorable say-on-pay vote. In the survey data, and we can thank, Soma Brasi for some of the data that we're going to be citing in the materials. 75% of the companies in the survey get over a 90% approval rating on their say-on-pay. 91% of the companies in the survey have got something in excess of 70%. You can be assured that these companies do not align perfectly with IFS guidelines or Glass-Lewis guidelines or other institutional investor guidelines. There will be variations in those policies, in the compensation practices of those companies, and yet, resoundingly, they're getting positive votes. We'll talk about what some of those practices might be and how you can address them to your investors. The second thing, which is not on the slide, and again, I think it is self-evident to our audience, and that is that the results of a say-on-pay vote are extremely important to senior management of companies and boards. And if, in fact, you find yourself in a position of, getting a poor vote with respect to a say-on-pay initiative or with respect to a comp initiative, generally both boards and management will want to be taking some specific steps to correct that. And we'll talk about what one of the key emerging practices is in that area. Slide 5, we won't spend a lot of time on it, gives some details on companies that haven't succeeded. Again, it's in getting a positive say-on-pay vote. It's a minority of companies, and there's some companies that repeatedly fail on say-on-pay. Slide 6, two things to take from this slide. One, if you get a positive say-on-pay vote in 1 year, it is quite possible that in the next year you could get a very negative say-on-pay. This is not it was 90 1 year, 80 the next year, and 70. In fact, the winds can change, very, very quickly based on a new pay practice, a new plan, or on, changes in corporate performance, largely driving that result. So you get the disalignment. The other thing to take from this slide, again, an important point to keep in mind, is that it is very easy with the right kind of effort and the right kind of disclosure to turn a negative vote into a positive one. I mean, it requires some effort, but there is a way to take, and you can see from the slides, what are very, very low say-on-pay percentages and turn them into positive results. Slide 8, we talk about what is essentially, part of the emerging best practice in managing your comp program and disclosing it. We'll talk about the importance of shareholder engagement in a minute. But the first thing I want to mention, and I know Linda will be covering this a little bit later in the presentation, but nothing on this slide or in any other part of the presentation substitutes for a robust and well-thought-out compensation committee process. So what we are talking about here is in addition to what we all do as part of the compensation committee process. I won't highlight all the good things the compensation committee should be doing. There are 2 or 3 that are important for my money. A calendar that's set with topics assigned to meetings, not that you can't have other meetings, but that there's a well-defined calendar that allows management to sort of feed information in. an intelligent approach to taking minutes, very important topic. You want to capture the right amount of detail to document what you're doing, but not so much. Quantification of decisions, big in terms of helping you understand what you're doing and also communicating your message to shareholders. And lastly, considering the disclosure implications of anything that you are considering as a compensation committee and are going to be submitting either to shareholders or describing later in the proxy. At the time of approval, you ought to be considering, what that's going to look like, how the disclosure is going to play, and how effectively it can be described to investors to tell the story to investors about what you're doing at the comp level. On slide 8, the second point to keep in mind is that the emerging practice that we want to focus on is ongoing shareholder engagement with your investors. Essentially, not a program that, as it has been in years past, that is reactive, but rather a proactive approach to dealing with your investors on a regular basis, allowing a core group of your management team to reach out to them, get your message out, listen to what they have to say, and take that into account as you make your decisions with respect to for your senior management. Slides 9 through 11, I'll just gloss over them, but they give you some of what is essential, what are some of the key aspects of an emerging shareholder engagement process. You need to identify your key team. Normally we view that as a management team. We don't typically put in the ordinary course, directors on the front line. You can in some instances, particularly if there is an issue, but a regular team of management to address key investors. Target the investors that you want to focus on. You don't have to reach out to all of them, but you do need to focus on your key investors. And listen. The majority of what we like to think of shareholder outreach program is an opportunity for your investor group to tell you what's on their minds, to tell you how your program fits into their model for effective compensation design and compensation governance. We have a slide on fair disclosure, FD. In our experience, FD is important. As I think we all know, the SEC has a more aggressive enforcement policy and is focusing on, even minor infractions. But as a practical matter, what we have found is that FD really doesn't interfere. It informs, but it doesn't interfere with an effective shareholder outreach program. The goal is to hear what your shareholders have to say. Most companies are doing, a very, very good job at getting their comp program out in their proxies and through their filings. So really you're talking about not pushing new information out, but pulling additional information in. And it's only rare that FD would actually create an issue with respect to effective shareholder outreach. The last slide I want to cover before I turn it over to Linda is slide 13, which reminds us that companies are not only reaching out to investors, but they are also disclosing their outreach in their proxies. And 62 of the 100 companies that we surveyed had some form of shareholder outreach reported in their proxy, and that's a significant 38% increase in prior years. Just to give you a couple of examples of that, because I think it is informative. One company that had some issues with respect to say on pay results in an earlier year included a chart or a table that basically summarized what they heard and what they did. Two other companies basically mention as part of their say on pay disclosure and the solicitation of say on pay vote that they regularly make outreach. There are a lot of examples out there. But the key is that not only do you do it to set the table regularly, but it's becoming an emerging best practice to disclose it in the proxy as well. With that, maybe Linda, I'll turn it over to you, or Darrell, if you have anything to add to that.
Well, this is Darrell Lewis, and let me say at the outset, thank you very much for inviting me to participate in this discussion. You know, these topics, these are very, very challenging issues to all of us who are out in the field every day serving on boards of directors. And, you know, when you're trying to balance the need for retaining an executive against, you know, having a compensation plan that is totally consistent with the quote-unquote best practices, it can be very challenging. But I want to say, Ken, that I do think it's very important for members of boards to be proactive rather than reactive. You know, it's always possible to act rather than react. And so if you stay out in front of issues and stay out in front of it and engage shareholders to understand, number one, that shareholder base, to understand the shareholders' policies, what they believe is important. It helps you when you formulate your strategies in implementing the best possible plan for your respective company, because all companies are different. They come in different sizes, shapes, ages, and they're different. So what works for one may not work for another. But at least you can take that information into consideration when you are formulating that plan. So the key takeaway from what Ken is saying is, you know, be proactive with respect to it and stay out in front of it, as opposed to reacting when something doesn't happen the way you want it to, like a negative say on pay vote, or you don't get as many votes as you thought you would. So that's my takeaway early on from what you've said thus far, Ken.
Thanks, Darrell.
Thank you, Darrell. And this is Linda. I'm going to take it for a few minutes from here now, now that Darrell and Ken have given you some background and set the table. I'm going to help us.
Excuse me, this is Jim Christie. Before you get cranked up here, maybe I should interject with the CLE credit code and give our audience that, and then you can get underway. To earn CLE credit, you must include this code on your individual lawyer affirmation form. The numbers are 9188-9408. That's 9188-9408. Thank you, Linda. Go ahead.
Well, thank you, Jim. Now I'll start by saying that now that we've talked a little bit and given you some background and some of our orientation, I'd like to focus on a little more detail on the actions that may be likely to present problems for your say on pay vote as directors as you make your decisions, and what can be done if you're thinking about stepping outside of those guidelines. The next 5 or so slides review the policies that ISS and Glass Lewis, who are the two most prominent proxy advisory firms, what they indicate they use to evaluate a company's executive comp practices when they're making their recommendation on say on pay. Their policies in today's world really define the playing field, and they can help flag for directors when their actions may be taking them out of bounds from the ISS's or Glass Lewis's point of view. So I'll touch on a few of the highlights on these slides. I'll leave the rest for your reading pleasure. But I do recommend that directors, and particularly directors on compensation committees, familiarize themselves with these policies because being forewarned is, after all, being forearmed. But before moving on, I just want to mention that by highlighting the policies of ISS and Glass Lewis, we don't mean to suggest that they are the beginning and the end of a company's analysis. Many institutional shareholders have their own guidelines and policies, and if an institutional shareholder base is what you have in your companies, the company should be aware of the policies of their institutional shareholders as well. Reviewing ISS and Glass Lewis policies do nevertheless provide a good overview of the hot buttons. Before I move on, I'd just like to pause and put these discussions in a context similar to what Darrell just mentioned, because there are times when a board will conclude that it is in the best interests of shareholders and the company to make an executive compensation decision, notwithstanding the fact that it may well trigger an issue under a proxy advisor's policies. There may be times when a board will be able to sidestep the issue with creative structures and design, but there will also be times when that's not possible for a variety of reasons. It's particularly interesting and particularly important in these situations when a board decides to exercise its independent judgment and decides that an action is in the long-term interest of a company and its shareholders, notwithstanding a likely proxy advisor's recommendation. It's at these times that the advice we're discussing today is particularly relevant. So many of you are probably familiar with ISS and Glass-Lewis voting policies. I'm going to go over them briefly because there's a lot of detail that can be dealt with. There are three main points to remember with ISS. The first is that it will or may well recommend an against vote on SAN pay if there is, firstly, a misalignment between CEO pay and company performance. And as we all know, the link between pay and performance is key in all of our analyses. ISS approaches this with a two-part test, which uses both qualitative and quantitative measures. On the quantitative side, they have a peer group alignment test and an absolute alignment test, the latter of which looks at the trend between CEO pay and company total shareholder return over the prior 5 years. As a practical matter, I think it's fair to observe that if a company passes the quantitative tests, it's generally less likely that ISS will feel that the qualitative tests will present a significant problem, but they will focus on whether there is a misalignment in their view, and therefore should the qualitative factors be looked into more carefully to determine whether the pay elements work to encourage or undermine, in their point of view, long-term value creation. Some qualitative factors that they go into, for instance, is the ratio between performance-based and time-based equity awards. ISS will also be looking at realizable pay versus grant pay in the future. All of these intended to try to balance, from their point of view, the link between pay and performance. The second and very important thing to keep in mind that ISS says that it will take into consideration is the extent to which they feel the board exhibits poor communication and responsiveness to shareholders. For example, in connection with responses to a poor SAN pay result, also perhaps in communicating goals and their role in determining compensation. These are things that can be dealt with through proxy disclosure, and regardless of where you feel you're setting the bar and whether ISS might or might not feel it's appropriate, it's a way for you to communicate and have an impact on ISS as well. The third point to focus on is that ISS will look at whether the company maintains significant problematic pay practices, and that is their phrase, not ours. Take a note that their emphasis is on CEO pay, not executive pay generally. And if you'll focus on the slide, I think it's slide 19, that's titled Significant Problematic Pay Practices, there you'll see a list of the things that ISS is likely to look at. They say that none of these are automatic negative recommendation triggers. In experience, I think we have found that some of these practices are likely to result in a negative say on pay recommendations. So be warned and think about these. I'll highlight just a couple. One is excessive perquisites or tax gross-ups. In today's world, many companies have curtailed the excessive use of perks, but some still exist. The private use of company airplanes is a hardy perennial, and if the use is not reimbursed by the executive and is grossed up for taxes, this may prevent a serious problem. That is one that can be kept in mind, should be kept in mind. A second problematic practice under ISS's policies is the payment of bonuses without justifiable performance linkage. That's not surprising. A particular hot button for them is the payment of discretionary bonuses when, from their perspective, the performance support is not abundantly evident. A related hot button is a change or cancellation of performance goals without adequate explanation. These are just some flags and warnings for you as boards as you go forward. because these things are things that come up all the time.
So, Linda, this is Ken. I just wanted to add to that, in that, a number of the things that we list on these slides are truly egregious practices. I mean, they can be viewed, negatively in and of themselves, but there are a lot of practices which arguably fit or don't fit within the categories that ISS has enumerated, which you will sometimes decide you need to adopt for good corporate reasons. Single versus double trigger. Obviously, single trigger cash severance is pretty easy to spot. But whether you have a double trigger with respect to equity, there's quite a bit of range in terms of how an equity program can be structured with respect to payment triggers for vesting or termination and settlement of the award in the event of a change of control. So there's some flexibility there. Generally, we all think of purposes as something we don't want to have, but there is still some prevalence of certain purposes like airplane use. It doesn't mean you get a negative say on pay vote. The challenge of bringing a new executive on and the kinds of sort of bonus or make-whole compensation that you may need to do to get that. Again, these are areas where with a program of regular shareholder engagement and with the proper storyline and disclosure, we think that there is some room to maneuver away from a strict reading of ISS, Glass Lewis, or other investor guidelines. Thoughts?
Thank you. I don't disagree. I do think that the shareholder outreach and your engagement with your shareholders is key in overarching issues that could involve ISS or Glass Lewis. And the question is, how relevant are their recommendations to your particular shareholder base, and how can you influence them? There are statistics that indicate on a Russell 3000 basis that the ISS or Glass Lewis recommendations could move the dial 25% on the votes. So there is good significant data on that. Needs to be kept in mind. So it does present an obstacle. I think we're saying they're obstacles that sometimes can be overcome, but need to be dealt with. Moving on to Glass Lewis very briefly, in determining its voting recommendations for say on pay, they use a less formulaic approach than ISS, allowing for more flexibility and potentially more unpredictability, I suppose. They review executive compensation based on the company's industry, size, performance, and frankly any other factors they deem relevant. There are four main areas that they look at when reviewing say on pay proposals. Not surprising. They look at the overall design and structure with particular emphasis on the performance metrics, the quality and content of company's disclosure, the absolute amounts paid, and the link between comp and performance. Different from ISS, Glass Lewis pay for performance analysis looks at all named executive officers in the proxy statement, not just the CEO. They also have problematic pay practices. There are some listed on page 23, many of which are similar to ISS. Bonus practices, again, are key, as is any failure of the pay for performance link. So again, these are things to keep in mind as you move forward in your decision-making process. But once the compensation committee or board senses that it may well decide that it's in the company's best interest to take an action that doesn't fit strictly within these proxy advisors or guidelines or best pay practices, what steps should it consider from the beginning to help secure a better positive say-on-pay vote? So let's turn to the counseling side and to talk about some things that could be considered, and again, not all sizes fit all. But first, I think important to mention is for the board to try to clarify and formulate the reasons for its action, so it can help cogently and persuasively explain them in the proxy statement. We all know that in a room there can be 6 or 7 different points of view, and you can all get to the same decision, but you may not have consensus on what the reason is, and some reasons may be better than others. The process used in reaching consensus on the reasons for the actions will probably, in and of themselves, help guide the decisions and sharpen the board's thinking. So we think that's an important point to think about. Secondly, consider all of the elements of the compensation program in the light of the decision you're making. Is there something that could be adjusted or eliminated or tweaked a bit that might help the proxy advisor's assessment given the decision you're going to be making? For instance, maybe add more rigorous vesting or performance criteria to a long-term incentive award that you're going to give if the proxy advisor might consider it to be very large. Like structure tweaks might help and put it in a different light. Third, and again, things to think about as you undergo the decision-making process. And this, I think, is important, certainly for the lawyers in the room, but generally for all directors, is to check your governance process. This, as Ken mentioned before, it's always important to have good practices in this area, but particularly when you're encountering something like this. And ensure that the board has all relevant information to make an informed decision. This is in line with the duty of care of the business judgment rule that you're all well aware of. Consult with compensation consultants and attorneys if you think it will help you with the risk assessment you're undertaking and help advise you in the process. I'll note that many compensation consultants can run analyses, computer analyses, that will help you determine the likelihood of ISS or Glass-Lewis reaching a negative consensus on your TSR performance. That might be helpful. Ken mentioned taking care of preparing minutes. I'll mention scheduling sufficient time for the deliberations. Ideally, for my money, I'd like to see more than one meeting. If you can have a meeting to discuss it and then some time to sleep on it with a second meeting where you finally make the decision, that I think is often very helpful in giving people time to deliberate, thinking it over, thinking it over again, and then clarifying your thinking about why you're doing it so you can communicate it well. Quickly, it's important to just take another check on the independence of the board members participating in the decision. It's key to be sure that there's nobody in the room with a conflict of interest. And lastly, confirm compliance of the decisions with your plan provisions and previous disclosures in your proxy statements. I think this last point in particular merits just a moment's emphasis. There's a developing plaintiff's bar in this area that reads proxy statements very carefully and from an informed point of view. And they're checking to see if board decisions comply with the terms, for instance, of the shareholder-approved plans. Do a compliance check to make sure that the things that you're doing really do fit within the parameters of what all your plans provide. Lastly, when you're making your decision, consider whether there are any issues, again, from the proxy advisor's perspective, that you might address that could help counterbalance your decision and maybe low-hanging fruit. For instance, if you haven't taken any action on some of the actions that are listed on page 26, they may be things that you might consider grappling with as you make a possibly problematic pay practice decision, such as adopting a policy prohibiting option repricing or backdating. These things can maybe help in your analysis. Before I go on, Darryl, I don't know if you, from your experience, would like to add anything to this discussion, because it really reacts to the dynamic of the boardroom and making these hard decisions.
Well, thanks, Linda. And what I would say is the takeaway from what Linda was saying, don't be afraid to ask for help. I always quote Abraham Lincoln, who said that he who represents himself has a fool for a client. And so I believe that every compensation committee, with very, very, very few exceptions, should have a competent, capable, and prepared lawyer advising them on all the legal implications on all board decisions regarding executive compensation. And with respect to the proxy advisors and all of the things that they say they look at to determine whether or not they will recommend a vote against or vote for executive compensation plans, don't be, again, afraid to ask for help. There are good consultants out there who can help. As I indicated before, every company is different. And what I would suggest is, depending upon the circumstances, interview a few to see who works best with your company and see if you can get a consultant to help navigate some of these ISS and Glass-Lewis issues so that, some of the things you can change in an executive compensation plan to be consistent with what they're saying. And then some of them, if you can't, be able, with your consultant and advice of your lawyer, to, like Linda said, explain it, document it, and explain why, and why your company is different and shouldn't necessarily comply with what they're saying, so that you can spell it out very, very clearly in your proxy statement, because like Linda is saying, there are people that are looking, and to see there's a growing plaintiffs bar that are looking at these issues like Linda is saying. So that's the takeaway from what you're saying, Linda, from a practical standpoint, from someone out here in the field on a board on the compensation committee.
Well, thank you. I'll just make a few comments about what happens from our perspective, what to think about once the decision to take the action is made. What's the next stage? So really the next stage focuses on communication and persuasion, very simply. Ken's already discussed preparing your team, choosing your team, clarifying the message. Making use of proxy solicitors' review of your shareholder base can be very helpful. Focusing on the preparation of your proxy statement, it may need reformatting based on your decisions. You may need to put in an analysis of performance that's different from some of the metrics that ISS might look at, such as TSR. Important to try to avoid platitudes and be a true communicator, and also to remember the concerns of the various audience members you may be addressing, such as your shareholders and proxies or advisors. Highlight the shareholder engagement efforts that you've undertaken in the past and how they've played a role in your process, summarizing your feedback. Consider summaries, as Ken has said, but most importantly, tell your story, the reasons why, and why you feel that the pay-for-performance rule is satisfied, notwithstanding what some of the ISS or Glass-Lewis practices might be. And one last practice point. If a director or another person who sat in on the deliberations is able to spend a little bit of time explaining the board's reasoning to the team that's tasked with writing the proxy, that will be time well spent. Sometimes getting a prompt from the director that it's a good idea to not just mark up the proxy that you had last year, but signaling that there may be a need for a different approach and that the drafts people are given fair rein to do that, that could be very helpful. And then the next step will be engaging with the shareholders, as we've already discussed, keeping SD considerations in mind. I'll mention that most institutional shareholders that I'm aware of will not review written materials that are different from the proxy unless they have already been filed with the SEC. It may be true that you may feel they are not presenting material and non-public information, but I think from the safety perspective, institutional shareholders often won't take that next step, so it's just something to keep in mind. And keep in mind also that they are busy people as well, so it's a good idea to try to schedule with them early and get in there before they get any busier than they already are. Lastly, consider engaging the proxy advisors before they make their recommendation. ISS may, in its discretion, be willing to meet with companies before formulating its recommendation. In a speech recently, they indicated that every year, in one form or another, they speak to a majority of the S&P 500 companies and plus a fair number of Russell 3000 companies below the S&P 500 level. You'll have to take your best shot, have really good arguments, but you might have some luck there. Last thing to mention is the S&P 500 companies generally get a shot at looking at the ISS draft report to check for factual errors.
So we have another group of slides now that deal with the question of what do you do if you get a negative recommendation. I'll cover those, then turn it back to Linda to talk about what happens if you get a negative say-on-pay vote.
Ken, it's Jim Christie. Don't lose your train of thought. Let me just jump in here with that final credit code before you get cranked up.
I'll write that down.
For the audience, to earn CLE credit, you must include this code on your individual lawyer affirmation form, 91889408. I'll repeat, 91889408. Thank you, Ken. Go ahead.
So without going through every slide in detail, five key takeaways with respect to what you do if you get a negative recommendation. The first is to make the point which Linda made earlier that a negative recommendation is not fatal, but it does hurt. On average, when you look at the stats, say-on-pay votes generally 25 to 30% lower when you have the headwind of a negative recommendation, and particularly if you keep in mind both the Glass-Lewis and the ISS thresholds of 75 to 70% as numbers, that kind of swing can put you into, essentially what those two advisors view as negative territory. The second thing to keep in mind, important point, is that when you're in proxy season, it's a busy time of year. You filed your proxy, you get a negative recommendation. There's generally not a lot of time between getting the recommendation and the recommendation being disseminated to investors. So the ability to sort of gear up to effectively engage with a proxy advisor after you've got the negative recommendation without setting the right kind of framework for that with institutional shareholders and without having prior discussions, you are going to be fairly limited. There's not a lot of space to really effectively engage. It's a busy season. There's a lot of coverage, and it's very, very difficult to get the kind of attention you're going to want in that circumstance. The third takeaway is that if you are going to challenge a report, your strongest approach, the best approach, is when you are making the challenge on the basis of factual or empirical errors. So essentially, rather than challenge on policy, rather than challenge on theory, if there are factual problems with respect to the materials, or if there are just, the numbers aren't right, in terms of, a direct approach to a proxy advisor, you're more likely to get traction there than if you are dealing with it more on a philosophical level. The fourth approach, which we have been echoing through this presentation, is shareholder engagement is key even at that point. Investor engagement is key. If you've already built a relationship, it's now easy to approach your institutional investors, or easier to approach your institutional investors with respect to the story that you want to tell. And, as most companies have and continue to do a good job at describing their compensation programs in the materials, as a reference place to sort of tell your story with reference to the CD&A. The fifth and final takeaway is the question which we get fairly frequently is whether or not supplemental proxy materials are a help or a hindrance. And the conclusion is that the evidence is decidedly mixed. It's very clear that an effective outreach program that focuses on the facts and the story with the right kind of foundation can have a major impact. But when we look at the stats overall, what we see is that when companies file supplemental proxy materials as compared to those that don't in the face of a negative vote, they actually get a lower say-on-pay result than companies who don't file the materials. So there is an opportunity to use supplemental proxy materials. We're seeing them decline a bit in the marketplace, the use of these materials. And it is not assured that filing those materials will necessarily get you the result that you want.
If I can, I think part of what your point is, do it only if you really have something to say.
Yeah.
Sometimes you'll change your mind. A board will say, we're going to make a change. If you have to communicate a change, that's certainly a good reason for supplemental materials. But really do so only if you have something to say. There's a bit of cynicism out in the world about them.
I agree. So with that, maybe Linda, now we've sort of teed up the negative recommendation. Now despite all our best efforts and all our shareholder options, we get a negative vote. What do you do?
Yeah, so that's the question. What should be done after you receive a negative say-on-pay vote? And maybe the first question is, in a director's mind, maybe how terrible is it to lose a say-on-pay vote? And not surprisingly, maybe the answer is it depends. It depends on your shareholder base, for instance. If you have large institutional shareholders, will they give the company more time if given a fuller explanation of your midterm plans, for instance? Under what circumstances might these results destabilize your shareholder base, on the other hand? Ultimately, will your company become a target for unwanted press coverage or maybe even shareholder activism? These situations, unfortunately, can act like quicksand. Once you're in the middle of it, it's hard to extricate yourself. So it seems to be advisable to consider the ramifications and decide whether all or some of the steps we're discussing make sense for your company. It's clear that ISS and Glass Lewis will review more critically the disclosure and compensation policies of companies that have in the previous year received relatively low approval ratings. ISS uses 70% as its norm, and Glass Lewis 75%. Generally speaking, we think if you're around the 75% level, it may be smart to start thinking about engaging with shareholders as a defensive measure. And so what might be your next steps? Maybe it makes sense to consider a 12-month recovery plan for the next annual meeting. This is back to the same principles we've been talking about, only with a slightly different emphasis. Who should lead this kind of engagement effort once you've had a bad say-on-pay result? In many instances, maybe in this case, you should involve a director or maybe the chair of the compensation committee. It makes sense to do this in consultation and often together with either the general counsel or the head of executive comp. The important thing here is to use a person who's a good communicator and can, importantly, be a good listener. Listening to your shareholders to gauge the real reasons they did not vote with your say-on-pay proposal will be important, and trying to show some willingness to consider their ideas.
I would also add, Linda, that under the ISS and Glass Lewis guidelines, if you do get a negative vote or a low vote, even if it's positive, there is an expectation that you will have a shareholder outreach effort. So even if you haven't set the table with a program to, reach out to your institutional investors, if you get a low vote, part of the rehabilitation process is the requirement that you actually reach out and then disclose, what's happened based on that.
Absolutely. And there's some very good proxy examples for people with charts and executive summaries that have done check the boxes or different kinds of graphics to show, make it clear what they've done. It also makes sense, obviously, to really understand the proxy advisor's report, to consult with the proxy advisors if you can. But once you've gotten to this point of the virtuous cycle, once you've received the feedback, it makes sense to stop for a moment, I think, and review it with the entire compensation committee and maybe even the board so that they really understand with some texture the feedback. Maybe it'll influence the format and clarity of your proxy, as we've mentioned before, but it may also influence some of your compensation decisions for the next year. We have here on one of the slides, we mentioned some areas that may merit attention. Again, these are focusing on hot buttons, different kinds of structures or design elements that can aggravate the say-on-pay performance analysis, but more central issues, and particularly concerning pay amounts and the goals that have to be met, should be thought about and addressed. A side benefit of this process is that it also provides the directors an occasion to speak frankly with the CEO concerning these issues and hopefully engage him or her in helping the company address the issues as you go forward. And as part of this virtual cycle, consider circling back to your shareholders, maybe the proxy advisors also, to discuss their feedback and tell them what adjustments you have made, and importantly, explain why you may not have made some of the adjustments. As noted before, institutional shareholders may provide a company extra time to adjust pay practices if they see that a plan is in place to address the issues over the medium term, and that's an important thing, and this all goes into really having a relationship with your shareholder base. You'll see a chart here, and we've already talked about this a little bit. It's just an example of how you can turn around negative pay say-on-pay votes in the following year if you follow some good practices. And if you have a minute, you can review some of the case studies that we have in the slides. They do follow a trend. They have to do with improving disclosure, improving thoughts behind the performance metrics that are required to be for payment, to show shareholder engagement and describe it, and to try to eliminate what are viewed to be outsized payments for a variety of reasons that don't match up with pay for performance. I don't know if you have anything else you'd like to add, Darrell. We have a few minutes also for any questions that the audience may have posed.
Linda, I think you all covered most of it. Just improve the disclosures that you make, listen very carefully to the shareholder's point of view, and when appropriate, modify the pay practices consistent with that feedback that you get from your shareholder outreach program.
I will mention that in one way, the SAM pay vote is a blessing, or there's a silver lining to the cloud, because both ISS and Glass Lewis have taken the position that the SAM pay recommendation will be its first step, rather than attacking the potential election of directors that may be responsible for SAM pay decisions. They have taken the position that they will only generally recommend a vote against the election of a director, but particularly they focus on the chair of the Compensation Committee in these regards, if they feel that there has been a series of years without responsiveness or egregious practices, as they call it. So that may be the silver lining to the cloud of SAM pay, that SAM pay really can act as a safety valve for the directors.
And I will note also that, most companies, the vast majority of companies, have annual SAM pay. You can't have triennial SAM pay. One thing to consider is if you don't have annual SAM pay, you're on a sync with Glass Lewis or ISS, the possibility of reverting to an annual SAM pay vote to give your investors an opportunity to review, where you are, and it's a basically, I want to say no cost, but a lower cost type of change than some others that you might be able to, that you might make that can be effective. It's showing, a willingness to engage proactively and productively with shareholders and give them an opportunity annually to sort of say how they do your pay practices.
One of the interesting things that I found in reviewing some of these case studies, Ken, was on the Motorola proxy. They made a point of saying in their shareholder engagement discussion that it's their intent to have an outreach to their shareholders 2 times a year. First in the November and December range of time to gain feedback and concerns from the last cycle, and then in the March-April range of time to answer questions and provide clarifications and to hear their concerns. So, of course, the other side of this is a tremendous expense for some companies to do this. It's a time requirement for very talented people to spend time doing this. We think it's probably time well spent, but it is a challenge for companies that are not don't have the resources that some of the companies that are household names have.
So that's related to a question from the audience, which I think is relevant here. The question is, by publicizing in your proxy statement that you reached out, doesn't that just risk having other investors pushing for similar face time the next year with the company?
Yes, I think it does, and I think that this goes back to your shareholder base and understanding it. Some companies have a retail shareholder base, and you're not going to have meetings with shareholders with 10 shares, although they may ask for them, and you may feel that you should for a variety of reasons. In challenging times, you try to reach out to shareholders that account for more than 70% or at least 50% of the votes that will be going towards SAM pay. But you're right; it's a commitment, I think, of time and resources. And you may have to do this to a greater extent than you might feel in the first place. But sometimes you can deal with it by having a different group address different shareholders. The head of executive comp might be, with a telephone call from that person, might suffice to satisfy a shareholder's interest in discussing things with you.
Okay. Good. Well, I had another question, so if you want to go ahead and add color to that one.
Oh, I was going to agree with Linda, and I also, I think that the idea here is shareholder engagement, and so to the extent that you are getting, meaningful input from shareholders, that's something that you should welcome. I think that is where the market is, and the risk of getting engagement with too many shareholders, I think is very much outweighed by the benefits of having a program, protecting your compensation committee members by, giving them the information that you get from that program and disclosing that you do it in a proxy. I think that is a positive, that outweighs any risks associated with, encouraging additional input where you may not want it.
Okay. A couple more questions from the audience. We have about 5 minutes left in the webinar. This one I found really interesting. Does a company at its first annual meeting need to have a say on pay vote?
Yes, it does. It also needs to have a vote on the frequency of the say on pay vote, because you can do it either 1, 2, or 3 years, and that an advisory vote on that is required as well. And we're talking now for companies of a size. I mean, the Jobs Act gives exemptions from a variety of these kinds of requirements to smaller companies.
Well, that slides right into the next question, which was, do you have any compensation advice for small companies that aren't subject to maybe these larger company rules?
Yeah, I mean, we represent a range of clients, and one of the things that we do pre-IPO, right? So when companies are about to go public, or with smaller companies, within the limits of the resources that are available, is to try to manage to big company practice, because that's the goal, right? To grow your business, and when you start with a tough set of comp practices, it's very hard to dislodge them as you grow. So I think our best advice is, if you're not required to do something and you can do it, and it's consistent with sort of the full range of practices that are out there, we tend to encourage companies within commercial reason, to try to comply as fully as possible. Linda?
Nothing to add.
Okay, then I guess we have time for this. This might be a little bit more complex, but a final question. And any questions we don't get to will be provided to our presenters for later follow-up. But this is on, are there any areas of plaintiffs' litigation where you're seeing more of relating to comp pay and packages? And are there any successes by plaintiffs in these areas?
Well, very few of them, if any, have gotten to the judicial decision point. I think what usually happens is that a plaintiff's law firm will send a letter to a board of directors or management noting something that they think is out of sync from their perspective, and raising it as an issue with the inherent threat somewhere in the background that this could lead to litigation. One area that comes to mind that's worth mentioning maybe is the limitations that all of our all of our incentive equity plans have because of Rule 162M with respect to limitations for annual grants for individuals or in the aggregate. Given the recent slide in we now have stock prices that are going up. In the past several years, many companies' stock prices were depressed. And if they wanted to give a dollar amount of equity awards, it required giving more shares. And sometimes, maybe inadvertently, certainly inadvertently, a share limit may have been crossed. So that's the kind of compliance thing, check your limits in plan, that can avert those kinds of questions from shareholders.
Yeah, I would add to the 162M piece two things. I mean, 162M is complicated. It is often not disclosed, in the most user-friendly way. And I think plaintiffs have picked up on the disclosure and the limits. What has happened more in that situation, in my view, is changes in the way companies approach the disclosure, rather than any sort of meaningful judgments with respect to failure to comply with the securities laws because of the 161 disclosure in proxy statements.
Terrific, Jim, for our close.
Okay, great. Thank you, David. And on behalf of the directors and boards team, I want to thank our Sherman and Sterling colleagues for sponsoring today's webinar and for leading this informed briefing on standing out from the crowd in your handling of executive compensation decision-making. Ken Laveriere and Linda Rappaport, you did a terrific job and were very informative. And thanks go out to Darrell Lewis for joining in with his important perspective from inside the boardroom. Thank you to our listening audience for your time and attention to this presentation. You will be emailed the slides from today's presentation, and you can look for that, and a replay of the program will be posted to the Directors and Boards website. At this time, let me bring back Dagmar to join us and close us out.
Thank you. This does conclude today's webcast. We thank you for your participation. You may disconnect your lines at this time and have a great day.